then it looks like we have all of the board members. So call to order then the Farragut Board of Zoning Appeals meeting of August 26, 2020. This meeting can be viewed live on Charter Channel 193 and TDS Channel 3. The meeting will be held virtually as authorized by Governor Lee's executive orders regarding the COVID-19 pandemic. I'm Keith Alley. I'm the board chair. The first item of a 3-item agenda is the approval of the minutes for the July 22, 2020 meeting. Have we had an opportunity to review those?
Yes.
All right. Do we have any motions?
I'll make a motion to approve the minutes from July 22nd, 2020.
All right. And do I have a second?
Excuse me, I will second.
All right. Having a first and a second, any discussion? If no discussion, then call for a vote. All in favor of approving the minutes for the July 22, 2020 meeting, please affirm by saying aye. Aye.
Aye.
Aye.
Is anyone else?
Aye.
Is anyone opposed? All right. It sounds like it unanimously passes. And we will move on to the second agenda item, which is a public hearing on a request for a special exception related to the approval of site-related modifications at the ORNL FCU 11405 Municipal Center Drive, 1.3 acres, zone general commercial. Joshua Holden, attorney, applicant. And Mr. Shipley, typically we start with hearing staff recommendations. So what's going on?
Okay. I'm actually showing up as Trevor Hobbs, but I'm not Trevor Hobbs, so I apologize. We had to set up the recording different with a different computer. But yeah, this, as you all recall from last month, this was discussed in a different manner related to an administrative review. And the question at that time was whether the term terminal islands, as defined in our zoning ordinance and interpreted by the staff, as being required at the end of rows of parking that abut a building and thus required to be landscaped, was the correct application of the zoning ordinance text. And after looking through the definitions and illustrations, and basically the board voted unanimously to uphold the staff's interpretation of what constitutes a terminal island, that it is to be landscaped. That was really not a site-specific consideration, but the applicant did bring up the specific site in question, which is the ORNL building at 11405 Municipal Center Drive. And it was noted, by the staff, obviously we all, I know I hate that we're here discussing this matter, frankly, but unfortunately all this could have been avoided had there been plans submitted to and approved by the town to verify compliance with all applicable requirements for that portion of the parking lot. So having been denied on the administrative review, the applicant has now applied separately for first a special exception under this item, and then second, a variance under agenda item number 3 for the work that's been completed on the south part of the parking lot. The applicant in their memorandum brings up the sections of the statute in which the board can base its decisions on both the special exception and the variance. So since we're talking about the special exception in this case, one of the conditions that you see, I'm sure you've read there, is that the use has to meet all town requirements with regards to, among other provisions, landscaping, which obviously it doesn't meet the landscape requirements that was already hashed out last month. So it wouldn't meet that criteria, special exception. The fact of the matter is the construction plans that were approved for the project were included in this month's packet. And unfortunately, there were no plans on the work that was completed in the south part of the parking lot. In fact, on the architectural design standards checklist that we talked about last month, the designers actually noted that existing site work is to remain unchanged. So we had no idea that the modifications were being done to this south end of the building. So I think with this matter and with the variance request, from our perspective, it appears that the applicant is just trying to exhaust all their options, which they certainly have a right to do, but basically ask for forgiveness for something that was done without approval, and that does now not meet our requirements. I mean, we talked about the bicycle rack there in the picture. Doesn't meet our requirements. It's an obstruction. And then the width of that island also is non-compliant. So there's lots of things that they maybe had good intentions, and I'm sure it wasn't intentional, obviously. But all these things, could have been looked at and addressed with a plans review before the work was actually completed. And that would have avoided this whole situation in both this request and the variance. So, from our perspective, what we would recommend is what should have been done at the start of the project, and that is that they submit plans for this part of the parking lot as to how they're proposing to bring it into compliance. And then we'll review those plans and approve them, and then they would do the work necessary on the site to bring it into compliance so that the permanent certificate of occupancy can be issued for the recent work. So that's basically an overview of this item. The variance request is very, very similar, but there's, some different parameters there. But if y'all have any questions, I'll be happy to try to answer those.
All right, I'd like to open it up for anyone that has questions for Mr. Shipley. Does anyone on the board have any questions?
Mr. Chairman, this is Mike Wilson. I just want to let you know I'm finally on and have sound.
All right, very good. Good to see you. All right, if no one has any questions for Mr. Shipley, let's hear from Mr. Holden.
Mr. Alley, thank you. Can you hear me okay?
Yes, there's a little bit of a video lag, but that could be anywhere. So I can see you now and hear you.
Okay. Well, thank you. As an initial matter, I want to thank the board for hearing us again. I also want to point out that with regard to the previous administrative review, we filed it as an administrative review because that's what we were advised to do by both Tom Hale and Mr. Shipley. So we did what we were told to do. We're here today because the board at the last hearing essentially invited us to file for a variance, and we're hopeful that common sense will prevail today and the board will not require the credit union to bust up tens of thousands of dollars of freshly poured concrete for a few shovelfuls of dirt. At the outset, I need to address Mr. Shipley's argument that, as he says, quote, the board is being asked to forgive the applicant. That argument is just pure nonsense. The credit union can't change what happened. The decision was made on the fly while this project was under construction, midway through it, and no reasonable human being could ever interpret any of this to believe that expanding your handicap parking space at the expense of a little bit of grass and a shrub would be a bad thing. No one would intuitively know that. Okay. So the board's role is to figure out, and it's always the board's role, is to figure out how do we deal with what we have. Nobody can go back and change it. I mean, Mr. Shipley's argument could be used to deny every request for a variance or a special exception because someone along the way always could have done something differently to avoid the problem. A lot could have not been divided so as to be irregular, for instance, or the person who purchased an irregular lot could have elected not to purchase it. No one can change what happened. It was decided midstream, and it was done with the best of intentions, improving handicap parking space and making this facility more accessible to the members of the town. So this argument that somehow the credit union is stopped from receiving relief because it could have, would have, should have done something differently is just nonsense. That's not what the board's role is. So I want to eliminate that argument because it has no merit. With regard to the special exception, we've addressed that at page 8 of our memorandum. The notion that a special exception is not available because we haven't complied with the landscaping requirements is not accurate. The board is simply to be guided by all those factors taken in the totality. And so the fact that we don't have 2 shovelfuls of dirt on a concrete island or the bike rack, which can easily be eliminated, that's a 5-minute job rather than busting up $10,000 in concrete. The fact that we don't have that, I don't think, and I don't read the regulations as eliminating the relief requested by the credit union vis-a-vis a special exception. I would note, Mr. Chairman, that we would also argue that some relief, whether in the form of a variance or a special exception, and I don't know if you want to address these separately or collectively, given the similarity. Is there any preference, Mr. Chairman?
Just because of the way that we are taking it up on the agenda, if we can approach it from the standpoint of the special exception first, we can then move to the variance. I realize that the arguments may be related and similar, but if you can address the special exception for the purposes of the agenda item and they are separate, that would be helpful.
I will endeavor to do so then. Staying with the special exception, when you go through the list of factors to be considered, is the use consistent with adopted plans and policies? Is the use in harmony with the general purpose and intent of the zoning regulations? Is the use compatible? Will it have a negative impact on adjacent property? The credit union is perfectly in compliance with all of those. The purpose of even the landscape regulation is to soften the appearance of the hardscape. The credit union has tens of thousands of dollars in landscaping around its facility, all the way around it, up next to it. It's a beautiful facility. So we've complied with all of these. The fact that we are technically not in compliance with one provision of one doesn't eliminate our eligibility to receive relief under the special exception provision. I've got other arguments that I want to make, but I think I'll save those for the request for the variance.
Thank you, Mr. Holden. Do any of the board members have any questions of Mr. Holden? I have a question for you. So let me ask you this. If the bike rack you seem to indicate would be easy to remove, that's a matter of sawing something off perhaps and plugging some holes. And I believe when we were here last time, we talked about the fact that technically speaking, you could, or you might be able to, and I'm not suggesting what you do, but you might be able to remedy the landscaping with, I'm going to call it a potted plant or some sort of potted plant or something like that. So if you did that, why would you need a special exception if you can be in compliance by doing something like that?
Mr. Chairman, we're happy to take that up. That is something that we have has been a topic of discussion from the outset, and we feel like we need the board to bless that sort of action. But I think that's something worth consideration is using not. the phrase potted plant in my mind suggests something rather diminutive, but we were thinking something a little bigger and more robust in the nature of a large potted plant that you might see in a commercial retail setting, very large, that would satisfy the requirement to soften the hardscape and also bring the credit union into compliance with the landscape. But we feel like, to answer your question, the board would need to bless that either through a special exception or a variance. We would love to have that discussion.
Difficult, but we.
Hey,
Go
one
ahead.
other thing that's an issue here is the island width is not wide enough. It doesn't have the extruded curb, and then it's not 5 feet wide inside a curb to inside a curb. So that's another issue that they would have to address with that.
I think we get into the practical problem that the board really only takes up the issues before it and can't take up an issue not before it or suggest something. I mean, we are sometimes willing to talk through things, but we can't suggest that if you do this or don't do this, that you would be in compliance. We just have to look at the issue and make a decision on the issue. So that being said, certainly open it up for any other questions for anyone of Mr. Holden or Mr. Shipley.
Mr. Chairman, we did raise that issue in our initial memorandum. It's attached and incorporated by reference into what the board has before it today. The topic of using planters. So we would argue that it's incorporated by reference and then properly before the board.
But you're asking in the special exception, which is what we're on, is that you not have to do anything. I mean, so that's not in the special exception that you're saying. That's not a remedy you're asking for in the special exception, is it?
Well, I think as far as remedies go, we've asked for relief from the board from the requirement to completely tear out the islands. So I don't know that we've denominated specifically under special exception. We're asking for relief A, relief B, relief C. We've asked for general relief from the effect of the application of the rule.
Does anyone have any questions of Mr. Holden or Mr. Shipley?
This is Scott Meyer. Mark, could you please reiterate your idea of the special exception not being applicable in this situation? Earlier, you had mentioned something. I'd just like to hear that again.
Well, in the statute, it talks about, it gives a number of standards that you all would base a decision on. And then one of the standards is that permitted use meets all town requirements with regards to approval of the hydrology, engineering, building codes, landscaping / buffering, signage, etc. So yeah, it doesn't clearly meet that. So
Gotcha. Okay.
that was what I was getting at, and that and the handicap issue, the bicycle rack, the island width, all that stuff could have been avoided completely if we'd have just had plans that we looked at, before the work was initiated and completed.
Okay. All right. Thank you.
And Mr. Shipley, you're saying that it's not just a matter then of the landscaping element, it's a matter of the bike rack, it's a matter of the width, and that those things are all under zoning ordinance chapter 4 section 2 paragraph E 3F. It looks like those are all things that are not meeting town requirements currently.
Yeah, that's right. Yeah, those would be components of engineering and landscaping and just the site compliance. That's right.
All right. And for the benefit of the board members, in Mr. Holden's brief on page 8 of 10, which is in our packet on digital page 38 of 208, that is where I'm looking. All right, do we have any further questions for anyone? Or do we have any motions?
So, Mr. Chairman, Scott Meyer again, just a question of order. So are we to make a decision on the exception first and then the variance second? How, or do we need to make a motion to do both at the same time?
No, as I told Mr. Holden, because we have separate agenda items, my preference, just to keep it very clear, is that right now we are addressing agenda item number 2 on the special exception only. And so we would then move on after the special exception to talk about the variance issue, which is obviously related. If the special exception is granted, then that might make it moot. But I think we do need to have a resolution with regard to agenda item number 2, the special exception first.
Okay. So I move to deny the applicant's request for a special exception.
All right. And are they for any particular grounds, or the grounds articulated by Mr. Shipley?
The ground for the purposes on the grounds communicated by Mr. Shipley.
All right. Do I have a second for that motion?
This is Mike Wilson. I'll second.
All right. I have a motion and a second. Is there any discussion?
I may need to do a roll call if you don't have any discussion on the vote.
Certainly.
Mr. Chairman, this is Holiday. Can you hear me?
Yes.
So our decision is basically, does this situation meet the town's requirements or not, as opposed to can this be fixed? Is that correct?
I don't think that's technically correct. Basically, the motion is to deny the request for a special exception based on the reasons articulated by Mr. Shipley, which are, again, best identified on page 8 of 10 of the brief, which is page 38 in our packet, but that in our general review standards, which is zoning ordinance chapter 4, section 2, paragraph E, subsection 3F, the specifically permitted use does not meet all town requirements with regard to the approval of hydrology, engineering, building codes, landscaping, buffering, signage, etc. So, I mean, the issue is, the motion on the table is to deny it for that reason, that it does not meet the town requirement as articulated by Mr. Shipley having to do with the landscaping buffering.
Okay, thank you.
All right. Is there any further discussion? All right. If there's no further discussion, we will ask Mr. Shipley to call roll for votes.
Commissioner Meyer,
Yes.
Commissioner Wilson,
Yes.
Commissioner Collins,
Yes.
Commissioner Holiday,
Yes.
Commissioner Alley.
Yes.
All right, motion passes 5-0.
All right. Moving on to the next and last item agenda for this evening, item agenda 3, the related public hearing on a request for a variance related to site-related modifications at the ORNL FCU 11405 Municipal Center Drive, 1.3 acres, zone general commercial. Again, Mr. Joshua Holden, applicant. Mr. Shipley, do you want to tell us about this and how this is different than what we just heard on the special exception?
Well, it's different in that there's different criteria in the ordinance that you would base your decision on. We have the same perspective on both. Again, there are some positions noted in the memorandum for the applicant, feeling like they would qualify for relief through a variance. There's really, clearly no loss of reasonable use of the property by bringing the parking lot into compliance. That's, obviously, they're using the property now. They would be using it if the parking lot's brought into compliance. In fact, that's what's needed in order to get the permanent certificate of occupancy for the work that was completed a few months ago. And if you recall, the standards for variances are pretty high. There's, to get relief for those, you need to have a condition that's inherent in the property itself, not a condition that was created by the applicant, not a self-induced hardship, if you will. That basically, without you all granting relief, you've rendered the property unusable, and that's clearly, from a staff's perspective, not the case here. Again, similar to the previous item, the staff would recommend that the applicant have their designers get with us and submit a site plan that will address the existing non-compliant issues, and then execute that plan in the field so that they can finish the project and obtain their certificate of occupancy. But from the staff's perspective, there's clearly no grounds for a variance in this case.
All right. Does anyone have any questions of Mr. Shipley? Mr. Shipley, so if I understand correctly, with regard to the variance, I mean, you're just saying that, and again, I'm looking on page 2 of 10 of the brief of the applicant, which is our digital page 33. But the purpose of the variance is to modify the strict application of the specific requirements of this ordinance in the case of exceptionally irregular, narrow, shallow, or steep lots, or other exceptional physical conditions, whereby such strict application would result in practical difficulty or unnecessary hardship, which would deprive an owner of the reasonable use of the land. So if I understand what you're saying is that there's nothing inherent in the property making it unusable in terms of shape, that it can be used if it's brought into compliance, and that it's not a viable candidate for a variance.
Yes, that would be the staff's position, and that would be consistent with these matters that have come before you all in the past with the standards that we expect for variances. So yes.
Okay. Does anyone have any questions of Mr. Shipley?
Mr. Chairman, this is Mike Wilson. So I just wanted to clarify our ordinance with, I'm looking through the handout that we were provided on the powers of Board of Zoning Appeals, and I believe it's Tennessee Code Annotated 13-7-207. And in this handout that we were provided, it says, where by reason of exceptional narrowness, shallowness, or shape of a specific piece of property at the time of enactment of the zoning regulation, or by reason of exceptional topographic conditions, or other extraordinary or exceptional situation or condition by such piece of property, the strict application of any regulations enacted under this part and part 3 of this chapter would result in peculiar or exceptional practical difficulties to or exception or undue hardship upon the owner of such property to authorize upon appeal relating to the property of variance from such a strict application, and it goes on a little bit. So my question is, our ordinance seems to focus on, in the case of exceptional, irregular, narrow, shallow, or steep lots, or other physical conditions whereby, and it seems like we miss the or other extraordinary or exceptional situation or condition of such piece of property that the strict application could warrant. And I'm just trying to get a difference and read between what our city ordinance says, the town ordinance says, versus that paragraph I just read from Tennessee Code in the guidance that we were given when we joined the board. I'm just trying to see if there's a conflict there or not.
In looking at, this is Keith Alley, in looking at the language that I'd previously read from, that's again quoted in from the Farragut Municipal Code, Mr. Holden's brief on page 2 of 10. You know, some of the language is different, but the general requirements appear to be exactly the same from what you read and what appears in the Farragut ordinance. So I don't see or I'm not seeing a discrepancy between those. So word choice is different, but basically it's saying the same thing to me.
Yeah, that would be the
Okay.
staff's position as well. I mean, it's something that's extraordinary that's associated with the property itself. It's not a self-induced matter. It's something that's inherent with the property or some condition of the property itself, that without relief, that basically the property is not usable. So.
Okay, thank you.
Do we have any additional questions for Mr. Shipley? All right, then let's move to Mr. Holden. Mr. Holden?
Thank you, Mr. Alley. Let me just take issue with what Mr. Shipley just said, because the statute does not say that at all. It does not say that the property has to be rendered, quote, unusable. It says that nowhere in the statute. Nowhere is that in there. It does not specify that the condition has to be inherent with the property. That is not in the statute. It's not in 13.7.207. It does not say that. As Mr. Wilson noted, it says, or other extraordinary and exceptional situation or condition of such piece of property. It does not in any way limit it. It does not have to be inherent in the property, something created by God that was just always there. That's not in there. That would defeat the powers of the board. So I don't know why the board would read it that way. Moreover, on page 3 of our memo, under standards for variances, we set out very clearly, to use Mr. Alley's term from the last meeting, that the exceptional narrowness, topography, or siding are just illustratives. They're examples. They're not by way of limitation. 3A says variances shall be granted only where special circumstances or conditions exist. Parenthetical, such as. Well, such as means by example and not by way of limitation. There are other things that could come up that are within the board's power to correct, and this is one of those things. So under the plain language of the statute, I don't know how the board has interpreted these things in the past. Maybe this is different from how the board has interpreted in the past. But the right way to interpret it is to read the plain language of the statute, and it says, or other extraordinary or exceptional situations. There's no limitation on it that requires it or limits it and says it can't be man-made, or in Mr. Shipley's terms, self-inflicted. As grounds for our variance, we would simply note that we're only asking for the credit union to be allowed to do what we've now identified 36 other properties within the town of Farragut already do, including properties owned by the town of Farragut, including parks. People have concrete islands. They have rock islands. They have islands that are just striped with paint. We've given the town 36 examples, including recently constructed buildings that are not in, quote, strict compliance with the town's regulations. So we're just asking to do what other people are already doing, and for some reason, we're being singled out. Our request advances the public interest here by making the credit union more accessible to disabled members of the town of Farragut, to disabled patrons of the credit union. We feel like that's a more important interest than 2 shovelfuls of dirt, and a shrub. ORNL is in compliance with the spirit of the ordinance, which is the goal again is to soften the appearance of the hardscape. The credit union has ample landscaping, and our variance is sensible. Again, why are we requiring the credit union to bust up tens of thousands of dollars of concrete in order to put down some mud? And why not explore the planters that Tom Hale suggested? Again, we think that this is arbitrary enforcement by the board because we've identified literally dozens of other properties that are not in compliance. Why are we being singled out? Why is it okay for the town of Farragut to have a park that has painted lines at the end of a parking? I mean, we've identified dozens of properties that don't meet this terminal island requirement. Again, going to the public interest, does the board favor landscaping over the rights of and interests of disabled individuals? The credit union is going to be deprived of its property here because it's going to lose parking spaces. It's going to lose either regular spaces or handicap spaces. So there is a deprivation of the property. And if we're going to lose handicap spaces, then I think the board owes an explanation to the disabled members of the town of Farragut, the disabled members of the credit union who are watching this broadcast, and explain to them why they're going to make their lives more difficult. And then lastly, it's just common sense. During our last meeting, I made a note that I think it was Commissioner Holliday questioned the wisdom of making the credit union bust up the newly poured concrete only to, quote, dig a hole in the ground and put some vegetation in. Well, we wholeheartedly agree with that sentiment. Why are we doing that? That's why we've asked for this variance.
Do any of the members have any questions for Mr. Holden?
Yes, Scott Meyer here. So, Mr. Holden, my question is, I believe I heard you say that if the credit union tried to remedy the situation, that there would be parking spaces that I guess would be forfeited. Could you walk me through the math on that and try to help me understand how many spaces would be lost in relation to the number of like feet or inches or that would have to be given up in order to accommodate some kind of planting?
I'm happy to do that. I can tell you as an initial matter, the larger concern is the fact that the town of Farragut requires for each handicap space, you have a separate handicap aisle. And in the illustration that's on everyone's screen right now, you can see in the background, not in the foreground, but the 2 handicap spaces towards the background, you've got 2 handicap spaces and you have a large aisle, an exit aisle for a disabled individual to be able to get out of their vehicle and have plenty of space to maneuver. That wasn't always the case. Prior to this remodel, the credit union's parking lot, it had 2 handicap spaces, but it only had 1 aisle in between the 2 of them. And that doesn't comply with either the rules of the town of Farragut or, in our view, the ADA. So what we've done is expanded handicap accessibility. So if we do what Mr. Shipley says and we have to go over at least 5 feet, we're going to lose that aisle. Well, if we can't have the aisle, then we can't have the handicap space. So we're going to lose both the aisle and the handicap space, and we'll have to either lose additional normal parking in order to make a new handicap space, which presents an additional problem in that the lowered section of the sidewalk, the ramp area, is not going to be properly positioned to accommodate a new handicap space. So when you start down this path, it creates a domino effect of issues. It's not as easy as just going out and widening what's there, making it a little bigger and throwing some dirt in the middle of it. That's not going to fix the problem. This is going to be an expensive fix for the credit union.
That's exactly why I said they should have submitted a plan for the whole thing first before they did the work. And we would have looked at all of that on the front end to make sure that all aspects could comply. That was the problem. And that was a self-induced problem.
And as I've said, that's a completely nonsensical argument because the role of the board.
That's a completely logical argument.
Mr. Shipley, can I ask you a question?
I'm sorry.
Can I ask you a question?
Yes.
Do they currently meet or exceed the number of required parking, both handicapped and non-handicapped?
I do not know the answer. They probably exceed it, but I'm not positive about that.
Thank you.
Would Mr. Holden know? Mr. Holden, do you know?
The question is whether they meet or exceed the handicap parking requirement.
Both handicapped, you pointed out that if you had to reconfigure the handicapped, reconfigure the parking, you would lose some handicap spots. So my question to you is, are you currently at capacity on those required spots, or do you exceed the required parking? Because most places in Farragut tend to exceed the required parking.
Yeah, I can tell the commissioner that we're in compliance with handicap parking. I don't know if we're in excess of our normal parking spaces. I would assume that we're not under, or we would have been cited for it. So I suspect that we're adequate on our regular parking. I don't know if we have excess regular parking.
Okay, thank you.
Anyone have any further questions of Mr. Holden or Mr. Shipley?
I have a question for Mr. Shipley. If the current island there, looking at the picture, the current island with the bicycle rack, if that were to let's say disappear and go somewhere else, would that put it in compliance?
I'm not really going to get into site design at this meeting because that's not really the issue. What they need to do, and what I've mentioned in the write-up and said twice tonight, is a plan needs to be submitted so we can look at it, assess it for compliance with all requirements, and then correct the site to follow the approved plan. So I don't know the answer to that. We'd have to look at all the issues that Mr. Holden talks about. He's right. We got to look at all of them. We can't just look at the landscaping. We got to look and make sure it meets the handicap requirements. It meets the overall parking, island width, all those things. Obviously, the staff would wish this had been looked at before it happened. I was very surprised when I went out and saw what I saw. So, here we are, and that's all I can recommend at this point is that they submit a plan. We assess it for compliance. If it complies, we approve it, and then they change the site to make it comply. That's what we do
Mark,
with anybody else.
Yeah, I was going to say, Mark Aldermeyer here. So then you basically answered my question. Is it a normal routine process of the town to approve a design of a parking lot in this situation after it's been constructed?
Well, if they need to make a modification to it, then we would need to have, a design presented to us so that we can verify that what they're proposing before they do it meets our requirements, not after the fact.
So typically, our process is in the town that a plan is submitted to town staff for review, and that review includes compliance to all ordinances, and the plan is approved prior to construction.
That's right. Yeah.
Okay.
Yeah.
So in this case, that did not happen, and that would be
no, not for this, not for the work in this part of the parking lot. That's right.
Okay. So I'm sorry. Can we make a motion now, Mr. Chairman? Or
yes, if no one has any
Okay.
further questions, we'll certainly entertain a motion.
Okay. So I would like to move to deny the variance request from the applicant based on discussion from Mr. Shipley's point of view that this was a self-induced circumstance and it was not a circumstance tied to topography.
All right, we have a motion. Do I have a second?
Mr. Commissioner, may I be heard?
At this point, it'd be appropriate to have it during discussion.
Very good.
Mr. Chairman, this is Mike Wilson. I'll second.
All right, now is an appropriate time for discussion. Recognize Mr. Holden.
Mr. Chairman, before the board votes, I think it would be appropriate if the board would offer some explanation as to why there are 36 other locations within a stone's throw of the credit union that have painted on the concrete terminal islands, and that's okay. Why are they not before the board and the credit union is? I mean, if the board is going to deny this request for variance, which it seems poised to do, I think the credit union is entitled to some explanation.
The problem, Mr. Holden, is we don't have those other issues before us. We have no idea when those things were constructed, and it's simply not before the board. It would be completely improper for this board to speculate on why other things were built in the town that are not before the board. And I appreciate the sentiment, but that's just not something this board's going to do.
The board could ask Mr. Shipley why he's not addressed those in his response.
Well, I think it's something that ORNL can bring up to the proper authorities in the town outside of this hearing. I think that's entirely appropriate. And if there's something that's not in compliance that should be in compliance for whatever reason, I think that's something that the town has a legitimate interest in looking at. But again, I don't think it's appropriate for this board to conduct an inquiry into an issue that's not before it.
Very well.
All right, is there any further discussion? I have a motion and I have a second.
Mr. Chairman, this is Mike Wilson. I have real concern about the discussion, particularly with respect to the number of parking space required and the fact that we don't have that answer. Again, looking through the training materials we received on Tennessee Code Annotated, again, I'm going to quote this document I have. It says, this section reads, or by reason of exceptional topographical conditions or other extraordinary and exceptional situation or condition of such a piece of property, the strict application of any regulation enacted under this part and part 3 of this chapter would result in peculiar or exceptional practical difficulties to or exception or undue hardship upon the owner of such property. And the reason I keep coming back to this is if this piece of property is currently at the very minimum number of parking spaces required, and based on the language in the ordinance, the town is saying you must get rid of parking spaces, which then places the owner in a position where now they have not enough parking spaces. Now they're not going to get their certificate of occupancy because they don't have enough parking, and they're going to have to reconfigure the parking lot or do something else in order to gain that certificate of occupancy. So that's my logic, and I'm just concerned without having that information that I don't feel I have enough information to answer that question. And I understand under the rules that we operate, it's incumbent upon the applicant to prove their case. And so I understand that piece of it, but I do have concerns with that piece of it. And I'm not sure, I understand what our ordinance is, but reading this part of the law, I think after this meeting, we need to advise the town they should review this section of the town code, have the town attorney review this section of the code and make sure it does fully comply, and maybe clarify some language with respect to the requirement for a variance within the town.
I can get that answer for you if you can wait just a minute. I can find out how many spaces they have if you want that.
Thank you.
It's 1 per 300 is the ratio required for banks, but I can check on that if you want to take a 5-minute break.
Sure. Okay, thank you, Ms. Shipley.
All right, we're going to take a 5-minute recess and then reconvene in 5 minutes. I have it 7:52. We'll reconvene at 7:57.
Okay, I'm back.
The chair recognizes that it is 7:57. Mr. Shipley has rejoined us, and we'll just wait for the other board members to log back on.
This is Mike Wilson. I'm back on.
Holiday here.
Scott Meyer here.
I see Ms. Collins. Are you back with us?
Yes.
All right. And I see Mr. Holden. I think we're all back. So Mr. Shipley, we're waiting on you to tell us what the minimum requirements were for parking, I believe, and what they currently have. And
Yeah, it looks like based on, that was one of the issues was they didn't include that in their site plan set. So, but I can tell you by taking the footprint of the building, and it's one space per 300 square feet for a bank, they'd be required roughly 22 spaces. I counted over 37, so they're way over. And that wasn't even counting the modification to the handicap parking part of the parking lot. So even if that number's a little off a little bit, there's still several spaces over the requirement, which is actually normal for most banks are over parked by quite a bit. Home Federal, Bank of America, they have way more parking than what's required. So it's not uncommon to have that. So that would not be an issue as far as meeting the minimum parking space requirements.
But Alderman Meyer here, but this is all speculation because we don't really have the plan in front of us. So we don't really know.
That's right. Yeah, that's right.
Okay.
That's just based on the best available information I could put together. If it was close, I wouldn't, it's not close though. I mean, there's several spaces over the requirement.
Right.
So,
and I think the issue is the board has to make a decision based on the facts in front of us and not a speculation. And I appreciate, Mark, you getting the information for us, and that was very accommodating. But the facts are that we don't have the facts in front of us as to whether there would be a parking space issue or not. Unless I'm missing something. And I'm looking to the other board members. If I'm missing something, let me know. But I don't see, kind of to Michael's point, we don't know because we don't have the facts in front of us because there was no plan produced for the town to look at. So therefore, I don't believe I have any information or grounds to grant a variance if I don't have the facts in front of me. Based on
So this is Mike Wilson.
the hardship of our parking space. Sorry. Go ahead.
Sure. This is Mike Wilson. The reason that, you may feel I'm going down a rabbit hole, but the reason I wanted to clarify this, because I know this property, and I wanted to make sure that if we were under, if we put the owner in a position where they were under the number of required parking spaces, could they add parking spaces, or does the size or shape or something on the lot, would that become an impossibility? And so that's part of my thought train on trying to walk through this. And I just want to clarify for the applicant, I tend to lean in favor of disapproving the variance. In reading through some of this, these other documents, I'm going to quote a couple of things out of this training document that we were provided on Tennessee Code Annotated. And it does say later in this document, the hardship must bear a relation to the condition of the property as established in enabling statutes. In other words, it must have topographical problems or such unusual circumstances that the property cannot reasonably be used without the variance and a taking would occur. And that's McClurkin versus Board of Zoning Appeals from 1977. And then there's another piece in here that says, and let me find it. I just want the applicant to understand where I'm coming from. Let me find my other one. There's another piece of this that refers back to what Mr. Shipley talked about that this can't be something that's been induced by the developer, by the owner of the property. And I'm trying to find that reference in this document. So I would tend to, knowing that we think we have enough parking spaces based on the size of the building and the use of the building, I tend to support not approving the variance at this point.
All right, we have a motion and a second, and we were having discussion. Is there any more discussion? There's no more discussion.
Mr. Chairman, I did find that reference. If I can, just for the
Yes,
applicant, the courts have uniformly held where the hardship was created by the applicant's own action, he is not entitled to relief. That is Union Trust Company versus Williamson County Board of Zoning Appeals, 1973. So that would be another reason that in this situation, I don't believe it has to do with the shape or the size or topography of the property, but and this is, as Mr. Shipley pointed out, a self-induced issue. So under those two court cases, I don't see how I could support a variance at this point.
All right, thank you. Is there any further discussion? There's no further discussion. A call for a vote and ask Mr. Shipley to do a roll call.
Commissioner Meyer.
Alderman Meyer, yes.
Commissioner Wilson.
Yes.
Commissioner Holliday.
Yes.
Commissioner Collins.
Yes.
And Chairman Alley.
Yes.
And motion passes 5-0.
All right. Well, that concludes the agenda for this evening's meeting. If there's no further business, I will entertain a motion to adjourn.
So moved.
Do I have a second?
Second.
All in favor, say aye. Aye.
Aye.
Aye.
All right. Any opposed? Motion carries. Have a very good evening.